Well, unraveling the knot among the three fields named in my title of my paper, we can begin, I think, by admitting that feminism has effectively challenged mainstream criminal law theory from the liberal or Marxist through the psychoanalytic and up to postmodern approaches. It has underscored the gendered nature of criminal law normative universals. Having vocalized women's suffering, it showed that these universals have been and still are the tools of structural violence against women vested in the form of a point of viewlessness, of alleged neutrality. Feminism is partial and premised. It's always standpoint feminism, but it is neither idealistic nor materialist. It displays the original scene, let's say, of a society based on state, possessiveness, and maleness. Women's victimization remains disproportionately high, and their respective crimes go underreported, under-prosecuted. In the depths of Western society's male ethos, Blackstone's viewpoint on the alleged right of the husband to chastise his wife as long as he is being held vicariously liable for her crimes, as if these crimes are committed by a volitionally disabled person, remains the source of both domestic violence and the hands-off stance of law enforcement in this area until the 70s. As to domestic violence, radical feminism has made privacy public, and thus the intimate personal political. In McKinnon's words, women's no privacy is confronting private degradation as the public order. Radical feminism demands, among others, the mandatory arrest in cases of domestic violence. A theoretical objection is that a feminist approach should focus more on context and rather prioritize caring than promoting an inflexible normativism, which is allegedly connoting a male-based juridical attitude. According to that, mediation should prevail over deterrence. A practical objection is that arrest makes things worse, escalates violence. Consequently, a grey zone emerges where, apart from serious cases, for example, use of weapons, the felonious character of the assault is far from being the rule, and the arrest seems disproportionately coercive. So the objection goes. Although these objections make sense to some degree and underscore the demand for differentiations, for example, whether a shelter is appropriate or the perpetrator must be detoxified in the first place, or a deferral to the victim's preference may be the best way, etc., they cannot, I think, negate the need not to abandon radical feminism as a theoretical basis, favoring instead a kind of eclectic feminism of particulars, tentatively prone to lack of cohesiveness. Hybrid solutions may obscure things more than safeguarding effectiveness. Take the example of self-defense in the frame of domestic violence. In the United States, a transformation has taken place since 2005 in this field, as Jenny Suk shows. Lethal force to repel an intruder was initially accepted without obligation to retreat. This was the traditional Castle doctrine concerning house invasion, conceived of as boundary crossing. In the late 19th century, this right was expanded to all public spaces. In the late 20th century, a battered woman could claim the same right inside the house, but because she was considered incapable of retreat, because she has so many times retreated to the wall that an escape was no more possible. This incapacity can then very well be linked to the battered women syndrome, tacitly labeling killings in abusive contexts as pathologic, or at least as the behavior of a disempowered person lacking autonomy. With the above-mentioned new Castle doctrine, initiated by the Florida's Protection of Persons Law, she shows, the author I mean, that the woman can lethally defend her home against a cohabitant, against whom an order commanding him to stay away has been issued due to committed domestic violence. She can now stand her ground. She also may, according to each state's legislation, receive a temporary gun permit. However, her self-defense right presupposes her proven victimhood. Otherwise, the killing woman must have reasonably feared death or grave bodily harm to have her conduct justified. Whereas this requirement does not normally apply to residents facing a foreign intruder. There, the danger is conclusively presumed and thus cannot be rebutted with adverse evidence. What do we have here? We got a solution to be welcomed, surely, but also a legal subject construable simultaneously as both passive and lethal in a men's way. Without radical feminism as hermeneutical horizon, these perplexities remain invisible. And noteworthy is that in Cyprus, speedy procedure and austere exclusion rulings are provided for in a law of 2000 concerning domestic violence. Besides, corroboration is not necessary for conviction. In cases of rape, the problem is how non-consent and physical force are to be harmonized as criteria of the actus reus. Focusing on force narrows the scope of application of the law. Focusing on non-consent puts the victim on trial and misses the defendant's deed as object of the judicial inquiry. Further, as Tadros has shown, lack of consent presumptions function often as covert conclusions on the definitional constituents of the crime and not as mere evidential rules, that is, proving its concrete existence in the case on trial. McKinnon's dominance approach underlined the significance of subordination as a factor making the exertion of force redundant, but maintaining the harmfulness of the conduct nonetheless. Things seem worse if one takes into consideration her remark that domination, though socially constructed, proves to be less plastic than nature itself, that it gets naturalized, more difficult to change than biology. One is remindful here of the good Marxian doctrine of fetishization. The question arises whether a physically non-violent but still threatening or deceiving perpetrator can be considered rapist, or at least sexually assaultive or not. Taking non-consent as point of departure, a crime has to be affirmed in principle. This can require the establishment of lesser forms of rape, which could be denoted as sexual misconduct. For example, intercourse achieved through extortion and exploitation of a hierarchical relationship, consisting in the violation of the autonomy of the victim instead of the invasion into her person, understood as her psycho-corporeal integrity. So, lesser forms of rape, so to say. It isn't a matter of taxonomy, though. This is the reason why the comparison of sexual offenses with property offenses fails. You can succeed in comprehensively differentiating between trespassing, burglary, theft, robbery. You cannot if the whole range of personality violation, corporeal pain, and psychic emotional suffering through a non-consented to intercourse has to be considered. Nikki Lacey has hugely contributed into stressing the limitlessness of rape's evil in this regard, and together with Carl Smart, has also stressed the experience's silencing effect, which the standardized criminal law pattern leads to. But to avoid the vagueness of consent and the risk of under-enforcement, one has to dig deeper. I think that rape is legally based on a phallocentric narrative normalizing male sex drive, and complementarily on another indirectly phallocentric narrative identifying women as powerless and then, of course, sanctified victims, the ideal victims. What is underestimated, as Dempsey and Herring show, is some aspects, like the physiology aspects, that is, the by definition forcible nature of penetration into a masculine bodily cavity, the risk aspect, that is, the possibility of harming when its threshold goes beyond the trivial, and especially, which I would like to stress, the social meaning aspect, that is, the negative qua misogynist attitude towards women as sexual partners in the framework of a prevailing rape culture. The penetrated is devalued and objectified. They remind both us that McKinnon has already traced the misogynist attitude back to the linguistic structure itself. One may replace subject, verb, object with man penetrates woman. Well, she has used another word. She also traces it in the ideal of knowing subject itself. Feminists are beginning to understand that to know has meant to fuck, she says. Thus, intercourse is abstract endangerment of the woman, irrespective of a concrete occurrence of harm, that is. Thus, a prima facie wrong, which can be justified in its separate case, and not a socially acceptable or congruent behavior without criminal law interest as such. That it is primarily wrong is established through the fact that even if justified, it, as Dempsey and Herring again say, leaves a moral residue of regret. The wrongfulness, that is, can be overridden, but not cancelled. We touch here the profound base of a wrong not containable in the contours of formal positive criminal law, a wrong attributable to collectives. There is not the defendant who is raping the victim, but a faceless member of a certain gender lynching a woman. Victimization beyond individually traced harm, and the need for questioning radically heteronormativity, not necessarily only as an issue for lesbian separatism, for instance, or strategies for parodies, mocking and undermining mainstream meanings, as Butler would have it, but also as a component of a more holistic juridico-political transformative project. What this project has to pay attention to is that the boundaries between intercourse and violence, as well between sex and gender, are fluid. There is no pure sex opposed to coercion, no biological organs opposed to constructed classifications. And everything is intruded by the fundamental axis of domination expressed in the obscene, to remind here Zizek's wording, on universality of abstract criminal law, which presupposes what it purports to combat when it turns excessive. The nexus between desiring violence and the eroticization of subordination, which besides is the reason why the defendant's invocation of error of facts regarding consent, or his claim that the accusation was fabricated, may be considered as sustained qua reasonable. Under the light set by a more holistic approach, even differentiations among specific crimes turn superficial. What can persuasively make intercourse distinct from an assault consisting in allegedly mere oral sex, a problem which also the courts in Cyprus are confronted with? Or, even further, is a battered wife not simultaneously victim of a marital rape? Is Noah's the feast a metaphor of male genitals? Indeed, both crimes mean the same, that is, assaultive sexuality. Traditional criminal law on rape cannot retaliate enough, because the scope of harm suffered is not tantamount to the scope of the crime legally seen as committed. It's bigger and made invisible. Radical feminist proponents strive for the abolition of the provocation defense, to take another issue. Instead of requiring its expansion also to victimized women, they insist in the nature of provocation as male-biased legal term, which sanctions traditional men's rage and entrenches homophobic stereotypes by, for instance, recognizing as provoked a male defendant sexually but not violently advanced by another man. There's also here the Green case in Australian case law of 97. Well, the feminist insights have shown a deeper problem in provocation, conceived of as concession to human frailty. They have shown that anger, that is righteous indignation, should substitute for outrageous laws of control, that namely the criterion has to be normative, not naturalistic. Insofar, the ethical viewpoint of feminism harmonizes better with the discursive and enlightened nature of criminal stigmatization, whereas the undifferentiated legal concession to provocation betrays the subjugation to the necessities of a pre-legal state of nature. In the context of a radical democratic imaginary, righteous anger is the obligation of the unduly subordinated, the women first of all.